Okay, let's get started. Thank you for joining the webinar today. I'm Kimball Parker. I'm the CEO of SixFifty. And for those of you who are hearing about SixFifty for the first time, we are the technology arm of the law firm Wilson Sonsini. And in the technology space, Wilson Sonsini is like the New York Yankees of law firms. They helped found Apple and brought them public. Same with Google, Lyft, Tesla, SpaceX. About 2/3 of all the cool technology companies you've heard of have come through Wilson Sonsini. So we work with the law firm to create automated legal products like TurboTax, but with the best lawyers in the nation behind it. And the idea is to bring down the price so that a company doesn't have to be Apple to afford their legal help. And so we have a really fun, great job. So we build products for businesses who need legal help, and we also build products for people who need legal help. And we helped over 14,000 people at risk of losing their homes during the pandemic, all for free, with an automated tool called HelloLandlord.org. But today we are going to talk about everybody's favorite subject, the GDPR. Now, this is a very complicated area. We have some interesting expertise in this area, and I'm going to give you a little background on that. Wilson has some of the best privacy experts in the world. They have a privacy team in, I guess, spread out through offices in the United States, but they also have a big privacy team in Brussels, where the EU is headquartered. And actually, I got to spend a whole week out there last year, working with them to build this GDPR, to build our GDPR tool. A lot of our clients and the firm's clients have been struggling to kind of really figure out how to comply with that law. And so we worked with Wilson Sonsini to build an automated tool to help companies comply with the GDPR. And it contains all the legal documents you need, which we automated. It also contains training, data mapping, and a system to collect and respond to data access requests. It was a huge project, and we've helped hundreds of organizations comply with privacy laws. And so I'm telling you this because you're going to hear today from two of the main people who have worked on that tool, helped build it, and helped kept it up to date. And so first, you're going to hear from Marie Colbeth. She graduated near the top of her class from one of the best law schools in the nation. She clerked for a federal circuit court judge in the South. She worked in private practice for a little while, and then was a professor at BYU Law School. And we poached Marie away from BYU. And it was the best decision we've ever made. It's not an exaggeration to say that Marie is one of the top privacy experts in the nation. So be prepared to be impressed. The second person you're going to hear from is Austin Smith. Austin, like Marie, graduated near the top of his class at one of the best law schools in the nation. He's worked for some of the most important privacy groups in law firms in the nation as well. And we were able to kind of poach him away. We're very lucky to have him. Austin has helped with, actually, he said, almost every privacy law you can think of. Has experience helping companies comply. So we are very lucky to have Austin as well. You will be very impressed with him. A couple plugs, and then we'll be off to the races. If you're interested in learning more about our GDPR compliance services, you can learn more at 650.com/GDPR. 650.com/GDPR. And there you can sign up for a demo. You can learn some additional information. There's a video that kind of explains what our services do. And so if you need any help complying with the GDPR, we would love to help. Second, I believe that today's webinar is CLE eligible. And so we will post a code in the middle of the webinar and write that code down, and we'll email you the form with instructions to get credit. Finally, you can post comments in the Q&A section. There's a Q&A button at the bottom of your Zoom. You can put it into chat as well, and we'll answer it. But actually, we love it to be in Q&A. Then we can catalog them, answer them, and then we can even send out the questions and answers later if people want. So put your, use, just like Mark is posting in the chat, use the Q&A button instead of the chat for questions. And then, so with that, We are off to the races. I'm going to turn the time over to Marie and Austin, who we like to call the dynamic duo of privacy. Take it away.
Not a title I ever thought I'd have. Thanks, Kimball. So everybody, welcome to today's webinar. We're really excited to be talking a little bit about some of the new and exciting things that are happening in privacy in Europe. What we're going to do, first of all, is just sort of by way of agenda, we'll be giving some background because we know people on the webinar at different levels of knowledge in terms of the GDPR and what's involved in it. So we'll do some background, and then we're going to move into what is staying the same compared to what are some of the new changes you need to be prepared for. And then just the key takeaways, things we think are most important for you to understand leaving the webinar today. So with that, I'll start off and then we'll move over to Austin, but I'll start with the beginning of the background section where one of the most important things for everybody to understand about what is going on in the GDPR is that what we're focusing on today is transferring data out of the EU and into another country that's not part of the European Economic Area. These data transfers are something that is really common in business today. Pretty much everybody who's operating in the EU is sending the information somewhere if they're affiliated with an international organization, if they're affiliated with certain service providers. So it's really important that you understand what mechanisms you need to follow in order to transfer that data legally. So basically, we have the different mechanisms listed here. The first is adequacy decisions. Second, and the one we'll talk about the most today, is standard contractual clauses. We also have binding corporate rules and then derogations and exemptions. I'll talk about a few of those in more detail in a minute here. But the main thing to understand is that you have to follow one of these mechanisms in order to be transferring your data legally if you're transferring data out of the EU into a non-European economic area. So the one we won't spend much time on today is adequacy decisions, but there is one country where adequacy decisions are really important and really timely now, and that's the UK. So everybody's probably aware that Brexit became official at the end of last year, and so with that, the UK is no longer part of the European Union. That means that you can't just rely on taking data out of the UK into the EU and vice versa the same way you could before. However, the good news is right now you don't have to do anything differently in terms of being able to rely on a new data transfer mechanism. For the time being, the UK is in an interim period where the interim rule allows you to continue transferring data out of the EU into the UK. The really good news is that we recently had the EDPB adopt an adequacy decision saying that you can actually do this on a regular basis, on a go-forward basis. You don't need to do anything extra, but we're waiting for that decision to get approved. The member states have to actually approve that decision from the EDPB. So things are looking good. Still have a little bit of waiting time before we have an official adequacy decision that will last forever, or at least for 4 years before they review it again. But we do have one little hiccup that came up just yesterday, which is the Civil Liberties and Home Affairs Council, essentially, of the European Parliament has asked the EDPB, or sorry, the European Commission to amend the decision, the adequacy decision itself. They have some concerns about some UK data access practices that it's not that they want to get rid of the adequacy decision, but that they think it needs to address certain issues that aren't included in it regarding like bulk access to data, onward transfers. So if you transfer data from the EU into the UK, but then it gets transferred again out of the UK, they feel like the adequacy decision didn't really look at that closely enough. So they have some concerns that may mean that it stalls the timing of the approval of the adequacy decision, because they may decide to revisit it, tweak it, and then submit it for member approval again. So maybe a hiccup, but in the meantime, you're still good. The interim decision still applies. You can transfer data out of the EU into the UK. What's new is, of course, that you also now need a data transfer mechanism to transfer things out of the UK into the EU. Again, we have that adequacy decision from the UK. You're good to do it. But you also should keep in mind the UK is also recognizing any adequacy decisions of the EU. So if you're transferring data from, say, England, and you're transferring it out of England into Argentina, that's okay too, because Argentina has an adequacy decision from the EU, and the UK is recognizing all of the EU's decisions. So, long story short, you're safe. Things could change in the future because we don't yet have that final permanent approval from the EU.
And as we move to the next slide on standard contractual clauses, we also have a quick user poll to get a little engagement, asking what kinds of mechanisms you might be using if you're transferring data out of the EU into the US, the UK, Argentina, any other jurisdiction. So hopefully we can pull that up and see what participants are using. But while that's happening, we can go ahead with the standard contractual clauses and the rest.
Yeah, and this may actually help you answer the poll if this is sort of the first time you're really thinking about this information. Is the poll popping up? There it is. Okay, thanks. So standard contractual clauses, by way of background, are essentially an appropriate transfer mechanism where the parties, so the exporting party that's taking data out of the EU and the importing party that's importing it into another country, enter into these standard contracts where the essentially these clauses have been approved as being sufficient to protect the data of the individuals. So that could be the data transfer mechanism you're relying on. BCRs are binding corporate rules. Those are primarily used by international entities, so like your larger organizations. It's essentially an intercompany code of conduct that has to get approved by data protection authorities in order for it to be considered sufficient. So not a lot of companies are using those because it's a long process. There's a lot of uncertainty around it. Derogations or exemptions. So while not the rule, there are some exceptions that companies can rely on instead of relying on standard contractual clauses or BCRs. And of course, adequacy decisions, which we were just talking about, where some countries as a whole have been recognized as having adequate protections. And of course, some of you may be like completely unfamiliar with these and not know what your organization is doing. So those are the options. So we're going to spend most of our time today on standard contractual clauses. We'll give people a few more seconds to finish answering that poll. But with the standard contractual clauses, the main thing to keep in mind is that, by way of background, these contracts are considered, sufficient. They're traditionally attached to a data protection agreement, a DPA is what most people will call that. You need this if you are sending information out of the EU into a country that doesn't have an adequacy decision. It's really at this stage the only truly practical mechanism for the majority of companies, because the majority of companies don't have the resources and the level of expertise and technicality to go through the BCR process. So that's kind of what I'm expecting we'll see from the poll. I'd actually be interested if we want to go ahead and in that poll and see what the results are, see if that is, yeah, so that's sort of what we expected. So 64% of people that are in the room today are using the SCCs. A solid 30% are like, what is going on? So that's good. It's good that you're here in the webinar today. We can help you understand that. So essentially, like I said, these standard contractual clauses are between the data exporter and the data importer. They have a lot of drawbacks in terms of things that they're not really good at doing. And we're going to talk about that because there's been some changes to the SCCs that are sort of the crux of today's webinar. But essentially that's what they are. They're these contracts. They put restrictions saying like, you can do this with the data, you can't do that with data. This is how you protect the data. These are the sub-processors you're allowed to use, that kind of thing. And then previously, we used to be able to rely on the EU-US Privacy Shield. That was a data transfer mechanism where the EU had essentially, said, for US companies that are willing to subject themselves to these rules and this process, it will be will allow data transfers to those companies. And we had more than 5,000 US companies that were participating in that until it was invalidated by the Schrems II decision last year. And we're going to talk some more about why that was. The main issue was essentially that US intelligence agencies have an ability to gather data without providing sufficient protections to residents of the EU. So, the GDPR has promised that EU residents will receive certain protections regarding their personal data. And the court in the Schrems case essentially said, like, they can't uphold that promise because of, what's going on with the US intelligence services. And I'll let Austin talk a little bit more about what exactly was going on that they were concerned about. Austin, you are on mute. Apologies.
Apologies. The main issue that the EU was concerned about with regard to the Privacy Shield sending data to the US was what's called FISA, the Foreign Intelligence Surveillance Act. And it's very complicated. As you can imagine, the very high-level bullet points you need are as originally passed in 1978 to allow the US to surveil people electronically in the US for national security or foreign intelligence purposes. There have been some scandals before that. The most controversial section, as far as people overseas especially are concerned, is Section 702, which was added in 2008. And it basically allows for surveillance on people who aren't US citizens and aren't US residents, who are abroad, without a specific warrant ahead of time approved by a judge, which is what usually needs to happen. And this is, again, for people who are overseas, and the Attorney General, the intelligence community, have to provide targeting and minimization procedures. So like every year, lay out their whole protocol for how this works, and judges and courts do look at that and verify that that looks reasonable and acceptable to meet the needs of FISA and protect privacy of Americans and, to a lesser extent, people overseas. So it has limitations about who can be targeted. There are very strict rules about you can't say you're targeting some European person or someone in Africa, Asia, when you're really looking for an American's data that they're communicating with. Again, there's some judicial review. There's some internal mechanisms for objecting to specific instances of the use of FISA warrants, things like that, and there are strict restrictions on how the data can be used and shared. But the key fact being that this is not a specifically tailored warrant determination ahead of time saying, yes, this surveillance is okay. It's more of a broad programmatic approach to, we're using these procedures, is it okay to do that in general? So that was a huge issue for the EU in invalidating the Privacy Shield.
Yeah, and I'll say part of that is because from the American perspective, we do consider it to be strict because we've responded to issues that occurred and made it more strict in terms of protections, but those protections are more strict for Americans than they are for foreign citizens of foreign powers. So because of that, that is sort of that crux of the concern that caused the invalidation of the Privacy Shield practice. So that's what happened in Schrems II. When we refer to Schrems II, when you hear that in the privacy space, it's talking about this case that went forward in Europe and has gone through to, essentially it's been in the works for years and years and years. The first version did certain things. The second decision is the one that invalidated the Privacy Shield. But something else that it did that is really primarily important for everybody on the call today regarding standard contractual clauses is it questioned the use of standard contractual clauses. And it said, generally they're enough. So standard contractual clauses are still an appropriate mechanism to use. However, the adoption of additional safeguards through things like additional contractual provisions and other protections that you could put in place might be required. So, the standard contractual clauses could be enough, but they might not be. That's kind of what they said. And because of that, that determination in conjunction with the new standard contractual clauses that haven't quite been fully adopted, but they've gone through all the initial approvals. Those are what we're dealing with today. That's the new landscape. And we did just hear in April, we did get sort of a sort of message about the timing, which was that within a matter of weeks, the new SCCs should be fully approved and implemented. That was according to the European Commission head for international data flows and protection. Matter of weeks is, of course, subject to interpretation. It doesn't usually mean a matter of weeks. We're now here in May. This was in April, and they're not quite official yet, but we do think it will be really soon. So these new SCCs are what we're going to spend a lot of time talking about today. And they're here essentially because of what was going on in Schrems II, but also because of ongoing discussions within, the space generally about the fact that the old SCCs, they miss a lot in terms of what they account for, in terms of what's actually going on with international data transfers. So the new ones sort of try to fill a lot of gaps, both that were identified in Schrems and that have been identified by privacy practitioners for years. At the same time, so connected to that, we also did want to highlight the fact that the US and the EU have been undergoing recently under the new administration, intensifying discussions about enhancing the privacy shield so that maybe we can go back to a place where we could get an adequacy decision. So just as recently as March, we had a congressional research publication that came out that specifically listed out and made some suggestions for things that could help get us there. And I know, Austin, we were talking about this, and you actually mentioned that you had worked with one of the people that published this report.
Yeah, I worked at the Congressional Research Service for a few years, and Eddie Liu, who's one of the co-authors of the report, he and I worked on FISA issues and advising Congress about things like that. So if you want to dive into that whole background, this Congressional Research Service report on the Schrems II decision is a fantastic background. Highly recommend checking it out if you want to get into the weeds. We're going to move on, but we did also want to ask people if they had relied on the US Privacy Shield. We're going to do another quick poll to see how popular that was among people here. As Marie mentioned, over 5,000 companies had been using it. And just to take one step back and make sure we're on the same page about Privacy Shield, what was that again? What are these standard contractual clauses? The Privacy Shield was basically a mini decision by the EU that certain companies could be considered like Argentina. Argentina, as Marie said, is a jurisdiction where you can transfer data from the EU to Argentina basically without problems because Argentina is sufficiently protective of data privacy. The US generally is not, the EU has said, but under the Privacy Shield, companies could self-certify and say, we're doing all these things, following these boxes, and we're protecting privacy. And then you could transfer data from the EU to those companies. And it was as if that company was kind of a mini jurisdiction that had an adequacy decision. So once you certified, it was very frictionless to transfer data. That is what was struck down just last year by the EU Court of Justice. And so you can't use that anymore. The standard contractual clauses are the best alternative now, and they are, we're going to talk more about, but are clauses, contracts that have set language. You have to use the exact language. And if you're exporting data from the EU to the US, the two companies have to execute one of these contracts, and then you're allowed to transfer data out of the EU to the US. But you have to enter into those contracts with every company that's importing or exporting data. You can't just certify in general, we protect data like you could under the Privacy Shield. So that's the, again, high level background of what the Privacy Shield versus standard contractual clauses are. Maybe we can close the poll and see if people here have been using the Privacy Shield much, or if it was not something they've been relying on. So pretty close, 45% said yes, 55% said no. Again, it was a pretty handy way if you were making those transfers to do so legally under the GDPR.
And I'll say, oh, sorry, Austin.
No, go for it.
Delay. I was just gonna say, and it may be that you can return to that at some point because, we've got these discussions that have been renewed, but,
Yep.
all points indicate that, we're going to be a few years out probably from that actually happening.
Yep.
But there are changes that we could make that could bring it back. So some of the changes recommended in that report included things like legislation that would be national privacy legislation, similar, honestly, to what you see in California if you're subject to the CCPA, that could take away some of the concerns, so where you could potentially get us to where we might have an adequacy decision for the US and maybe not even need a privacy shield if that were combined also with some amendments to FISA. So they go through a lot of those permutations of what could it look like for us to get there, whether it's through privacy shield or maybe through an adequacy decision for the country as a whole. So
That's right. So that is where we are, how we got here. Privacy shield is gone. Now you have to basically rely on standard contractual clauses. What are those? And how are they changing? That's the meat of what's going on right now. So the first thing to emphasize is that the foundations of the standard contractual clauses are staying the same. They already exist, you can look them up, and there are new ones that are coming out, as Marie said, hopefully in a matter of weeks, that update them. We're going to get into what has changed, but first, the foundations. If you're already familiar with the standard contractual clauses, you don't need to learn an entire new paradigm. The basic framework is staying the same. As I mentioned, these are actual contracts, big, huge blocks of huge 3 or 4 pages of text that you have to enter into verbatim with the company that's either exporting data to you or that you're importing data from, whichever side you're on. And so you can't just, use principles and put them in your own language. You have to use this exact language, although the new ones will be allowing certain additional language to be added if you want to add non-contradictory things. And just generally, there are data processing principles that are staying the same under the existing ones, and the upcoming ones, you'll only be able to use the data for specific limited purposes. You have to minimize the data you collect to what's necessary, make sure it's accurate. Basic principles like that are definitely staying the same. And general obligations are staying the same. If you're exporting the data from the EU, you need to consider protection, take measures to make sure data is secure. If there's any problems that you understand in the third country you're exporting data to, you need to suspend the transfers, potentially modify the agreement if that would fix it, or let the supervisor authority in the EU know if you can't do that anymore. Again, those are existing and staying the same. Importer obligations, if you're the company in the US importing data, you can only process the data on the instruction of the importer. If you're a processor, again, measures in place to protect data, make sure it's secure, and you have to affirmatively tell the exporter if something changes and you can no longer comply with the clauses. So that's the foundation that already exists, and that's what's staying the same. But there are going to be a lot of new changes that we're going to be talking about going forward, largely based on Schrems II, that decision that invalidated the privacy shield completely and said the standard contractual clauses can survive, but with some adjustments. And then Marie is going to talk about the changes to those standard contractual clauses that are coming in light of Schrems II.
thanks, Austin. And I'll just say as I start this section to keep in mind, these new standard contractual clauses are for the EU. We have 2 questions in the chat asking about their applicability to the UK. And as you'll see when we resend the slide deck to you after this, somebody else asked if we were doing that. We are. These new standard contractual clauses are not applicable to the UK. They haven't been adopted yet. The UK is in the process of drafting its own new standard contractual clauses. So those are supposed to come out sometime in 2021. So the things I'm about to talk about are EU specific, not UK specific. If you are transferring data out of the UK into the US, you can continue to use the old SCCs even once the new ones get approved. through the end of the year, potentially for longer. When the UK does announce its new SCCs, it will tell us how long we can continue to use the old ones for before we have to switch over. So keep that in mind. This is all about to be EU specific, not inclusive of the UK. Okay, so one of the first things that I just wanted to sort of outline for you to help you understand where the SCCs fit into the overall process is that we've been told by the EDPB that essentially when you go through the process of deciding, how you're going to transfer data, what you're going to do with your data, that you need to follow a roadmap. So the first step in your roadmap is always identifying the data that you're handling, that you're processing, that you want to transfer, and assess what in your data sets does need to be transferred. So keep that again as a GDPR general principle. We should always be minimizing what you're doing with data. So if you have huge data sets and you only need some of it to be transferred outside of the EU jurisdiction, make sure you're only transferring that part of the data. Also, you then need to identify your data export mechanism. So that's what we're talking about today, right? Your standard contractual clause could be your data export mechanism. An adequacy decision could be your data export mechanism if you're sending the data to a country that has an adequacy decision. It could be a binding corporate rule. We did have a couple of respondents today say they were using BCRs. So you've got to identify your mechanism. Then you need to assess the data protection laws in the third country. And this is the thing that for most entities will be new. And it has been worked into these new SCCs. Like, what are some of the things you can do as you're assessing those data protection laws to do the next step, which is identify and adopt appropriate supplementary safeguards for your data. So if you're sending data to a country that maybe as a general rule doesn't have strong enough protections, what are some things you could do to create a stronger set of protections that would make it okay for you to send that data? So identifying those things, adopting those safeguards, and then implementing them. And then of course you would periodically need to reevaluate. So that's our roadmap. Within that roadmap, the SCCs are the most important for essentially every company out there, because that's how most companies are going through the data transfer process. And it's the way that 90% of companies are transferring data outside of the EU into the US right now, which is what most companies are most concerned with. So with the new SCCs, what are we looking at? First of all, they're modular, which means that instead of having, one set of standard contractual clauses for, controller to controller transfers, you have modules where you'll have parts of the contract that will be the same no matter what type of transfer you're doing, or they might be the same. As you can see here, I've got the different modules listed. They might be the same for module 1 and module 2, but different for module 3. So based on the relationship between the importer and the exporter, different clauses will come into that module. And what this is doing really is fixing a gap that has been identified for years in the current SCCs, which is they account for modules 1 and 2, but not for modules 3 and 4. So now we've got those, there's a lot of sub-processing going on at essentially every company in the world right now. So processor provisions are really important. It's something that just hadn't really been identified in the early days. And so now we're trying to come in and fix that. So we've got the modular aspect with the different relationships between the importer and exporter identified. You also have within these new SCCs some of the safeguards that were identified in Schrems II. So I was just talking about the fact that in your roadmap, you need to identify safeguards. Well, some of them have been incorporated into the SCCs, the new SCCs. And then also the guidance that has come out with these SCCs is that you should be reading them in conjunction with EDPB recommendations. That's the European Data Protection Board. Their recommendations about other supplementary measures that you might take. And we'll talk about supplementary measures in a minute. So these are some big differences that you'll see from the old SCCs. Some of the things that are nice about these are that it's easier to add additional parties. So say, you're operating, you want to bring in a new processor, you want them to agree to all the same things that have already been agreed to by the other parties. You can pull them in as opposed to having to execute a new set of contracts. It's also easier well, it's allowed for you to add new clauses. So say under the SCCs, there's a set of safeguards already identified that you're happy with, but you want to adopt additional safeguards. With these new ones, you're allowed to do that, whereas before you couldn't change them. So there's those allowances. And then you also are going to be having some trickle down requirements. I think this part is the part that will be the biggest headache for processors. So now some of the requirements that only really attached to the controller or to the data exporter are going to trickle down and say that the data importer, your third parties, your sub processors are going to have some additional compliance requirements that they have to meet that previously they would have been able to sort of put off on other parties. So that's probably the biggest change. There's some other things that I've identified here that I just want you to be aware of, but those are the biggest ones. And we're going to talk about some of these in more depth.
And I would just emphasize Marie's first point there about there now being 4 of the standard contractual clauses, 4 versions. Before, there was only controller to controller and controller to processor, meaning if you were a controller in the EU in charge of the data, sending data to another controller, another company that was going to use it how it wanted in the US, you were covered. And if you had a processor, a vendor in the US, you were also covered. But if you were a processor in the EU, if you were a vendor to other companies handling personal data and you needed to transfer it to the US for a sub-processor or to another company, you weren't technically covered. You had to kind of shoehorn the existing ones into trying to cover your situation. So just having 4 different ones is a huge improvement and just going to make things easier for a lot of companies in that way. That said, of course, as Marie has mentioned, there are a lot of other additional provisions to take into account, but I think it can't be overstated that just having options that actually fit the modern world is really important.
Yeah, it's one of those cases, right, of the law always lagging behind technology, and we're always trying to play catch up. So this is a place where there was definitely a need for catching up. And these are going to have impacts on your operations. So we've identified some of the main ones that will need to be considered sort of at the very first stage. The first of those is that we have had a couple of questions in the chat about this. There's a 1-year transition period once the new SCCs get their final approval. So again, this could be a matter of weeks. We'll see. But once that approval comes, you'll be able to continue to operate under your currently existing contracts that you have with the old SCCs for another year. What you will need to do though is if you're entering into agreements with any new parties, you'll need to use the new SCCs for those. And if you're on our platform, we will have those on the platform when they get approved. We'll roll them out to you so that you can have the old ones still, especially for those those of our customers that are relying on those because of the UK still using the old ones. We'll keep them on there for you, but we'll also roll out the new ones. So you'll have that option within our system if you're a SixFifty customer. So 1-year transition period. The nice thing about these SCCs is that they do meet all of the GDPR's Article 28 requirements. So you won't need a data protection agreement in addition to the SCCs. The SCCs will be able to stand alone, which they couldn't do before. They essentially had to be they operated essentially as addenda to contracts. And if you're a SixFifty customer, you've seen that. That's how ours operate. So the new modules will be different because they'll work together in a seamless way that doesn't require that DPA. And then I mentioned before, you can add additional clauses to them as long as they don't contradict the SCCs or in some way prejudice the rights of your data subjects. So that's a nice piece of flexibility that I think companies will appreciate. You'll appreciate as an individual company. At the enterprise level, you may decide not to do it because it's easier just to say, yes, we just have the standard SCCs. That's a lot easier. There's no need for us to go back and forth on the contract stage. So it does depend on the size of your business, whether you're really going to enjoy that new provision or just say, I don't even want to deal with that. And then one thing that will be harder, which again, like we don't have a lot of guidance on exactly what this will look like at this stage, is that as you're adding in additional safeguards, there's this requirement that you loop in the supervisory authorities. So the data protection authorities say, we want to, this requirement, that requirement, this is what we want to do. And we don't know what the feedback loop will look like on that. So that's still very much up in the air. It's the kind of thing that most companies are saying, well, we'll just go with the safeguards that have been identified as potential ones we could add. That'll be the safest way to go. But there are a lot of companies that have really great, high level security practices that are going to want additional safeguards that may not already be identified in your SCCs. Okay, so concerns. The biggest concern, I think the hardest thing for most companies with the new SCCs will be this thing that they've told you to do that I hit on in the roadmap, which is assessing the legal regime of the countries where you're going to be importing data. So if you're sending it from the EU to the US, assessing the US legal regime. We already know what the problems with it are. The Schrems case has highlighted them for us, so that's helpful in a way that we haven't seen. If you're trying to send data to another country where the laws may be in a language that nobody in your company speaks, and all of these things that can be really difficult. But essentially, with the new SCCs, both parties, when they sign them, they're declaring that they've taken into account the data transfer laws in the destination country. So you don't have to, re-examine the EU every time. It's staying the same. It's the gold standard, but you have to assess the laws in that third country. And then that's the stage at which you would need to identify additional safeguards if the laws are not protective enough. And so, the importer will also be required to give information to the exporter and continued cooperation if they receive what's in the second column, one of these government access requests. And so this is where the rubber really hits the road when a government in a non-EU country comes to you and says, we want access to your data, or you discover that they've been accessing your data in some way without your knowledge. That's when you will, under the new rules, be required to notify the data exporter, the data controller that you're engaged with in this agreement, that it's happened. Sometimes in certain countries, there will be rules saying you are not allowed to tell anybody we've done this. So if notice is prohibited, the rules also now will require that you use your best efforts to get permission for essentially an exemption that would allow you to notify the other party that it's happened. You also are required to document your efforts. So documenting and regularly updating the data exporters on requests that you have received. And that would include, part of what you have to document is reviewing the legality of the request that you've received, whether there are grounds for you to challenge that request, and then you're supposed to follow through. Like you're like, we have grounds to challenge, we're going to follow through on all of those. Have we exhausted those? And just documenting each step of that as you go through that process. We have had a question about like the applicability of FISA. It's generally applicable in the US. If you've received a FISA warrant request, like you know that they're a nightmare and that it's really hard to get any sort of exemptions. Typically, the smaller your business, the harder it would be to fight one of these because there's not a lot of clarity, there's not a lot of transparency. With that in mind, that's definitely an issue where you would want outside counsel. And that's something important to remember about all of this. Like you can do so much of the GDPR using the tools in our systems and all of those things, but there's some things where you should for sure be getting outside counsel, and that type of request is one where I would absolutely say you should be getting outside counsel before you respond, so that you know that you're doing the right thing, so that you know what your rights as a company are to object, and also if you think that you engage in the type of activity where it's likely that you may get this type of request, you might want to think about putting in place processes. And this goes towards the roadmap, honestly, like analyzing the data, analyzing the likelihood of this happening, and figuring out what safeguards you can put in place. And that's really kind of what we want to talk about here.
So there are a number of safeguards that you may need to put in place. The new standard contractual clauses specifically say that, as Marie mentioned in the roadmap, you need to assess what's happening in the country to which you're exporting data or importing it into, as the case may be. And if there isn't already, if the standard contractual clauses themselves aren't enough, which is strongly hinted at for many people in the US, you're going to need additional safeguards. The most common of these are the technical ones, and those are by far the most important, not to say they're silver bullets, but encryption, pseudonymization, split/multi-party processing, and I'm going to dive into those a little bit so you understand what those are, since they're the most important. But we also have our last poll to ask if people are using any of these or none of these technical safeguards, just to kind of get a feel for what's being used already. I will quickly say, before I dive into the technical ones, that contractual and organizational safeguards can also be very important, especially in a belt and suspenders type of approach. If in addition to technical things, you have public commitments to taking appropriate security measures, if you publish transparency reports, if you prohibit onward transfers, if within your organization you have strong training and policies and things, that absolutely can help, but usually can't overcome a lack of appropriate technical safeguards. So if we can put up the poll, I don't know if it's there on the technical safeguards. Encryption is in some ways the most straightforward. I think we've all at least heard of encrypting data. If you're sending information from the EU out of it to a third country like the US that doesn't have an adequacy decision, not like Argentina again, if you're encrypting the data, that goes a long way. However, there are different kinds of encryption at different stages of things that you definitely need to take into account. The key takeaway from these safeguards is that they all need to be assessed and implemented on a case-by-case basis. Some of the information you export might need certain safeguards, and other information might need fewer or more. So with encryption specifically, there's encryption in transit. While it's being sent, is it encrypted? Encryption at rest, while it's being stored, is it encrypted or is it in the clear and the processor or company in the US can access it and change it and things like that. The encryption you use, how strong is it? There are all kinds of different basic encryption methods that might be breakable within the next few years or already are somewhat weak. So we're using the strongest possible encryption. The EU's recommendations in this regard talk about needing to flawlessly implement encryption. So if you're using software that's decades old, you might not be flawlessly implementing the best kinds of encryption. So all that to say, encryption, there are a lot of facets to it that you need to take into account, and you really should be talking to your technical teams to make sure that that's happening correctly. The two others there of technical safeguards to mention, pseudonymization is basically what it sounds like, masking the name or other particularly identifying information about someone, email address, physical address. If, for example, you want some information to be processed in the US by a processor, or you're the processor from a company in the EU, maybe you can pseudonymize the information and only send, purchase history of people to the US for processing and not include any really identifying information. The key there is that you need to really strictly keep any information that could be used to de-anonymize or re-identify that pseudonymized information. You need to keep all of that in the EU so that there's no way the US company, whether it's you or a vendor, can re-identify it. And then there's split multi-party processing, which is somewhat similar to pseudonymization, but it's kind of breaking up the processing between different companies, none of which individually can know really personal data about people. And that's another possible safeguard to use if you're exporting it out of the EU to a country like the US. So those are the technical safeguards that are most strongly recommended. They may or may not be enough for you in all of your situations. Again, the takeaway here for these safeguards is you really need to do a case-by-case analysis and make sure any changes you make to data you're exporting or purposes for it, all of the safeguards, whether technical, contractual, organizational, are appropriate and in place. And did we have, oh, sorry, I didn't see the poll results. I think they just went down. I apologize. Here we go. So almost everyone's using encryption, which again, I think is the simplest, easiest one to use. again, with those caveats. Pseudonymization, pretty high as well. A third of people are using those. And a very few people are using split multi-party processing, 3%, and a few others, 13% each. On other technical measures or none. So there are definitely other options. And again, the more you use, the better, as long as they're being implemented correctly. So that is the gist of what we wanted to all go over. Maria, are there any other questions we want to answer live? I know that we've had a lot that I think would probably best be answered by text, which we do in a follow-up email, so that you can read what's happening in our responses. Some of it I know is very jargony, so it might be better parsed anyway by text. But Maria, is there anything we want to make sure to answer live before we get to the final takeaways?
Yeah, I think that we have a couple we could address with the group. One is many companies use certain collected data to improve their products. Can this be possible with the new SEC agreements? Will it require controller to controller terms? I'll answer that last part really quickly. It will depend on who's collecting the data and who's analyzing it. It may be if it's to improve your products, if you're the controller of the data, it would be probably controller to processor, but you might be the processor for another organization and you're analyzing the data for them. So it might be where you're the processor, they're the controller, or it could be joint control. It really would depend. So you can use data to improve products. Which terms, which module you would need would depend on the relationship between the parties there with the collection. Austin, what are your thoughts on sort of rules around, you know, what data you can collect for product improvement?
Yeah, and I think that's a really important question because that is becoming, you know, big data and just any data being especially valuable for improving one's own products. Again, as Marie said, it kind of depends, but to the extent that you can take data that was personal data and de-identify it or anonymize it sufficiently, it may not qualify anymore as personal data under the GDPR. And so I know some companies are able to do that, and whether through aggregation, whether through really stringent anonymization, can guarantee that it can't identify an individual, and then can be used to improve products, to train AI, to do things like that. But it is, again, something to be careful about, because if you don't have the right contractual terms in place and you start doing that, the EU could get very mad and come after you. So if it's something that is kind of an edge case you're not clear about, it could definitely be something to look to legal counsel directly for. But it's only going to become more relevant as companies are using data that they receive to improve their own products, to find fraud, to do creative things.
Yeah, and I'll say from the SixFifty perspective, because of that, we engage in anonymization. So when we're looking at, you know, data that we have to improve our tools, we anonymize, which is, I think, really helpful. There's another question that I think we'll hit quickly. I know you have some wrap-up takeaways that you wanted to share, Austin, but I think this one's interesting and helpful for a lot of companies, which is it sounds like from their description that they're collecting data directly from EU customers and sending it to the US directly. So they're wondering, do they need SCCs between them and the individuals, or would they need to get a subsidiary in the EU that would collect the information and then send it on to the US? I think this is really interesting because it helps us think about who's really collecting what data. So you may, and this is where I don't know your specific business, right? So I'm going to talk about a couple of different scenarios that might apply. You may be collecting it directly where it's being collected onto your servers, into your cloud through a system that you own. But a lot of companies that think they're collecting data directly from customers really are using service providers. So, you know, they have lead gen forms that are serviced by an outside company, or they're storing things in the cloud and they think they're collecting it directly, but really it's coming in through this third-party service provider already, even though nobody sees that, right? the end users don't necessarily see that you're using Shopify to sell them something. Shopify is maybe a bad example. They usually do see that. They may not realize that they're on some other platform. They may think they're on your platform. So, if they are on another platform, you would engage in the SCCs with that platform provider, and they would need notice on their platform about, what they're collecting and why. It's the same way you need your proper notices. But there is a derogation, and I didn't really spend time on derogations, but the GDPR does allow for you to process data outside of the EU with the consent of the individual. The problem with this is that consent is a really high bar in the GDPR. It's not just like click this box. It's like you have to tell them all these things, and it has to be really clear. They have to understand exactly what's happening. And you have to have equal bargaining power. So you have to have their consent. And then again, under the GDPR, if somebody withdraws their consent, you lose the ability to really do anything with their data, because they have the right to withdraw their consent and say, delete everything, do this, do that. And you have to, because you are processing it based on their consent. So I would suggest, if it turns out you are collecting data directly, you might want to actually consider that suggestion that the commenter made, which is maybe you do want to engage an EU service provider specifically so that they can take care of some of those things for you. Because consent it's really not always ideal. Agree, disagree, Austin?
No, I think that's absolutely right. And it actually leads perfectly, and we did not rehearse this, into the perfect first takeaway here, which is that the standard contractual clauses really are more important than ever with the invalidation of the privacy shield. They're not quite the only game in town. As Marie mentioned, consent is possible, but really is in many cases not ideal. So the standard contractual clauses, even as we saw in that quick poll we did of people here, is for most people the best way to send data from the EU, sorry, too many acronyms, from the EU to the US or another country without an adequacy decision. If you have existing standard contractual clauses in place, while the basic foundation is going to stay the same, there are huge changes, and you're going to need to implement these new ones once they come out, within a year after they come out. But any new contracts that you enter into with the standard contractual clauses will immediately have to use these new ones. So it's something to be looking out for in a matter of weeks. You're going to need to start to be ready for this. They're a better fit in general. Mentioned the timing already, it's here. There are going to be some indirect obligations that can flow down on sub-processors that might not have directly been subject to some of these terms. And the last thing to mention is just that we've been discussing the draft standard contractual clause updates, and we don't expect significant revisions, but they have not been finalized. They will be coming out, quote, in a matter of weeks again. And so there could be some changes from what we've discussed, but we fully expect all the principles we've talked about here to be pretty well represented. So these things are changing. You need to be ready. They're very important. The only game in town, really, for most people.
Thanks, Austin. Thank you all so much for joining us today. That is the end of the presentation. There's a few outstanding questions in the chat that we didn't get to. We will respond to those in the follow-up email. There will be a recording sent out along with the slide deck, so look for that in the email. And again, as we mentioned previously, if you are interested in getting some help with your GDPR compliance, you can go to SixFifty.com/GDPR. We've got some really great tools, and we'd be happy to help you. So thank you so much.